Ladies and gentlemen, welcome back to another legal breaking reporting video analysis update. We have an update as it regards to the Ninth Circuit Court of Appeals ruling unfortunately in favor of Trump and company to illegally, unconstitutionally send National Guard troops to Portland, despite there being no evidence of violence. Without further ado, ladies and gentlemen, we will be getting into the reporting by New York Times. By the New York Times. Following the reporting by the New York Times, afterward we have a scathing ruling or dissenting opinion by Judge Graber, who was appointed to the bench by former President Bill Clinton. Without further ado, ladies and gentlemen, let's get into the reporting by the New York Times. The reporting is by an automated voice, so we will be taking a look, a read, and a listen.
Appeals Court lifts block on Trump's Oregon troop deployment. This article is by Mattathias Schwartz and read by an automated voice. The Trump administration can move forward with deploying National Guard troops to Portland, Oregon, under a ruling Monday by the U.S. Court of Appeals for the Ninth Circuit. The 36-page ruling lifted a temporary block on the deployment of Oregon and California National Guard soldiers by Judge Karen J. Immergut of the Federal District Court for the District of Oregon. It was not immediately clear whether the order also allowed the president to use National Guard soldiers from Texas or other states, as he has suggested he might do. The ruling came from two members of the three-judge panel, Judge Ryan D. Nelson and Judge Bridget S. Bade, both appointees of President Trump. Judge Susan P. Graber, a Clinton appointee, dissented. The ruling opened the door to some federal troops being stationed at an immigration and customs enforcement facility in South Portland that has been the site of street protests since June. A memo in September from Defense Secretary Pete Hegseth said Guard troops could be stationed anywhere that protests are occurring or likely to occur, and could accompany federal agents enacting Mr. Trump's immigration agenda in the field. The memo came a day after a social media post by Mr. Trump stating that he would send all necessary troops to protect war-ravaged Portland from domestic terrorists. Such incendiary descriptions do not reflect the reality in Portland, Judge Immergut had written, and have been at odds with law enforcement agencies' own assessments of protest activity. But that has not stopped the president and other officials from misrepresenting conditions in Portland and in other Democratic-led cities where he wants to send federal forces. Much of the litigation prompted by his deployment efforts in Portland and in the Chicago area has turned on whether the Trump administration's accounts of violence at anti-ICE protests are accurate, and whether there is a basis for invoking a federal law that allows the president to deploy the National Guard if there is a rebellion or danger of a rebellion, or if the president is unable to execute U.S. law. In a preliminary ruling, Judge Immergut, who was nominated to the bench by Mr. Trump, found that while there had been some violent behavior, including the construction of a makeshift guillotine to intimidate federal officials, most of it occurred before June 25th. And none of it amounted to a rebellion. The two Ninth Circuit judges who ruled on Monday disagreed with her conclusion. However, their ruling is unlikely to be the final word in the dispute over the Portland deployment. The state of Oregon and city of Portland, which filed the lawsuit, could ask for an 11-judge panel of the Ninth Circuit to review the decision or appeal directly to the Supreme Court. Mr. Trump has some additional options as well. If the courts wind up going against his deployment, he could invoke the Insurrection Act, which would give him the authority to circumvent the court order now blocking a similar deployment in Illinois. That, however, would almost certainly be the subject of another round of lawsuits.
With that being said, ladies and gentlemen, let's get into the dissenting, scathing opinion by Judge Graber, who was again appointed by none other than former President Bill Clinton. Page 33 of the dissenting opinion reads, "We have come to expect a dose of political theater in the political branches. Drama designed to rally the base to rile, ladies and gentlemen, or to rile, intimidate political, or intimidate political opposition, pardon me, ladies and gentlemen, opponents. We also may expect there a measure of bending, sometimes breaking the truth by design of the founders. The judicial branch stands apart. We rule on facts, not on supposition, or conjecture, and certainly not on fabrication or propaganda. I urge my colleagues on this court to act swiftly to vacate the majority's order before the illegal deployment of troops under false pretenses can occur. Above all," she concludes, ladies and gentlemen, "I ask, ladies and gentlemen, those who are watching this case unfold to retain faith in our judicial system for just a little longer." Ladies and gentlemen, with that being said, this concludes this unfortunate legal breaking reporting of bad news. That's why it's an unfortunate legal breaking reporting for the ones that want to obey the rule of law, and is unfortunately in favor of the ones that do not want to obey the law. Ladies and gentlemen, let's hope that the state of Oregon and Portland choose either option of having an 11th Circuit Court review the case again, or appealing directly to the Supreme Court on this illegal move by Trump and company. With that being said, ladies and gentlemen, please stay positive and please stay safe. And I look forward to talking to you guys in my next legal breaking reporting analysis video.